Today I propose to discuss another important and equally debated topic from the scheme of Muslim law in India. And that topic is the maintenance right of a Muslim wife. It has already been pointed out repeatedly uh, in my previous lecture that nikah or Muslim marriage is in fact in the nature of a civil contract so far as the rights and obligations of the parties to it are concerned. It has also been pointed out uh, that after the formation of nikah or after the solemnization of nikah or marriage, it gives rise to various reciprocal rights and obligations to the parties concerned. On the conclusion of the marriage or nikah, certain obligations are imposed on the spouses, and at the same time, certain rights are vested in them, which of course are of the civil nature and can be enforced like a civil right in the event of breach of either of them by either party in a civil court through a civil suit or petition. One of the rights of the wife of a Muslim wife arising out of the marriage union is that her husband should maintain her so long as marriage subsists and continue, and she is under obligation at the same time to cohabit with the husband and make herself available to him. This is very crucial point that I want to raise, that the right to maintenance is also one of the exclusive right arising out of the contract of the marriage bestowed upon the wife, who is entitled to avail it from the husband from the day first, that is from the day the union of the marriage is brought about in existence and parties start living as husband and wife. Therefore, from the day first of the marriage, the wife, Muslim wife, under personal law becomes entitled to the maintenance from her husband, and at the same time, the husband is obliged by law to make the necessary provision for the maintenance and support of his wife from the day first and so long as marriage subsists and continue. The corresponding obligation on the wife is that after the marriage, she is required to cohabit with the husband and make herself available to him at all the reasonable time. So, on one hand, the husband is placed under a legal statutory obligation to provide on a reasonable scale maintenance to his wife. At the same time, wife is required by law, by the matrimonial laws, that she should cohabit with the husband, and thereby they should constitute a conjugal society, and formation of the conjugal society is must so that they can fulfill other obligations arising from the contract of the marriage. Hence, if the husband fails to provide the maintenance on reasonable scale to his wife, or the immediate and in-house remedy available to the wife is that she can refuse to live with her husband in the event of a negligence, or where the husband without any valid reasons fails to provide maintenance for a considerable period of the time. Then in that very situation, in that very case, in that very circumstance, the immediate remedy available to the wife for the enforcement of her right to maintenance is that she can refuse to cohabit with the husband. At the same time, this is the in-house remedy. The other remedy available to the wife in case the husband fails to provide the maintenance, that remedy is that the wife feeling neglected, or where she has been refused the maintenance by the husband without any valid cause or reasons, then she can file a suit, civil suit, for the enforcement of her right to maintenance, and the court, if otherwise is satisfied, may pass a decree or order for the payment of the maintenance to the wife who may be the petitioner or a plaintiff in a given case. So these are the two remedies available to a wife of the marriage, that if the husband neglects or refuses to pay the maintenance or to his wife without any reason or without any valid cause, then immediate in-house remedy available to the wife for the enforcement of her right to maintenance is that she can refuse to uh, uh, cohabit with the husband, can leave the matrimonial home, can desert the husband, and her leaving the matrimonial home and desertion of the husband will be justified and will be valid until the amount of the maintenance is paid by the husband to the wife. The next and the statutory legal remedy which is available to the wife in the event of non-payment of maintenance, that she can bring a suit in the court of the law, and thereby she can enforce her right to maintenance. And in case the suit is filed, then after due process, the court may proceed to pass a decree of divorce, decree of maintenance, and thereby the husband can be directed to pay the maintenance to his wife who is entitled to it by virtue of being the wife of the respondent husband. Ladies and gentlemen, one point is clear, that maintenance is an exclusive matrimonial right of a wife, and this right basically stems out of the union of the marriage, valid union of the marriage, and immediately after the conclusion of the union of marriage, means after the solemnization of nikah or marriage, immediately from that point of the time, she becomes entitled to be maintained by her husband out of his own available resources, having regard to the social condition of the wife as well as the status of the wife itself. Anyhow, the wife will become entitled to be maintained by her husband immediately after coming into force of the union of the marriage, which is called as nikah or Muslim marriage. This is not the charity on the part of the husband. This is basically obligation imposed by law on the husband to provide maintenance to his wife, to maintain his wife is basically the right that arises from the contract of the marriage, from the agreement, that is from the union of the marriage. Therefore, there should not be any mistake to understand that maintenance is not a charity by the husband to his wife. Rather, it is the obligation imposed by law on the husband, and it is the right of the wife. It is very natural right of the wife to receive it from her husband, that start immediately after the formation of the marriage, and therefore very natural question arise as to what is the maintenance in context of matrimonial law or under the matrimonial laws. Ladies and gentlemen, the term maintenance has not been defined under Muslim law. Even it is also not defined in India, that is under the CRPC code of criminal procedure code, that also deals with the maintenance of wife. Under the old law CRPC, it was section 125 to section 129 that deal with the statutory right of maintenance of a wife. Muslim law basically talks about the right of a Muslim wife arising from the Muslim marriage, whereas section 125 is secular in nature and seeks to address the maintenance right of wife of any religion, maybe the wife whose marriage was solemnized under the respective personal law. So, that is a general, but both Muslim law as well as section CRPC both speaks about the maintenance right of a Muslim wife. Just I told that maintenance is not defined under Muslim law. It is also not defined under the this CRPC, under the code of the criminal procedure code. There is no provision provided under the CRPC that defines exactly what is the maintenance. But under the Hindu Adoption and Maintenance Act 1956, word maintenance or expression maintenance is defined. Anyhow, the idea of the maintenance, what is the maintenance or what can constitute the maintenance, it is indicated through in the fundamental sources of Muslim law, that is in the Holy Quran as well as from the saying of the Holy Prophet. It can be inferred as to what may constitute maintenance as a right in context of a Muslim wife. Holy Quran at one place indicates, reflecting upon the maintenance. and provide for them the wives the worthy according to his means and destitute according to his means, a provision according to the uses. So a comprehensive idea of the maintenance is clearly indicated in this verse of the Holy Quran, that is the divine book. And the idea is that what will constitute the maintenance, or what should be the quantum of the maintenance, basically that is subject to the financial status of the husband in a given case. That one who is wealthy, he should give the maintenance to his wife according to his means, and one who is indigent, destitute, economically resourceless, he should pay the maintenance to his wife according to his means. And same is also clear from a saying of the Holy Prophet. A Holy Prophet in his last sermon, emphasizing over the maintenance of wives, said, the customary maintenance of your wife is incumbent on you. Means under all the circumstances, after the marriage, husband is under the divine obligation to provide the maintenance to his wife. Wife is entitled to receive it, to avail it, not as a charity but as a matter of right, flowing from a very natural union, that is union of the marriage. What may constitute the maintenance, that is left open-ended. Now it has been left to the attending facts and circumstances. What may be included in the maintenance, that has been left to the attending facts and circumstances. What will be the quantum of the maintenance, that has also been left to the means at the disposal of the husband. Therefore, the term maintenance is often described, or has often been described, with regard to the social condition of the wife, what a husband is required to spend for the overall support of his wife. So in nutshell, the term maintenance may be described as something or so many things which are required to be spent by the husband in a given circumstance for the support and dignified survival of his wife. Certain authorities on Muslim law also have made a successful attempt to recapitulate or summarize, in the light of the Holy Quran as well as the saying of the Holy Prophet, as to what may constitute or what is meant by the expression maintenance in context of a Muslim wife. One of the celebrated authority, ladies and gentlemen, on the subject of the Muslim law, classical authority on the subject of the Muslim law is Hidayah. Author of the Hidayah, he describes or defines as to what is the maintenance. According to him, maintenance signifies all those things which are necessary to support life, such as food, clothes, and lodging etc. It may also include articles as are necessary according to the customs of the particular class of the people, such as cosmetic, articles of domestic use, medical expenses, education expenses, expenses for cleanliness, expenses for traveling, etc., etc., excursion. All these things are included within the meaning of the expression maintenance. Therefore, maintenance has not been defined or has been put into a jacket formula. It is open-ended expression. And uh, normally the maintenance is confined only to the three articles, that is to the food, cloth and lodging. But as such, the expression maintenance cannot be confined to these items, that is food, cloth or lodging, but it may include so many things uh, which in the given circumstances may be necessary for the better or the dignified life of a human being in a given society. Uh, Therefore, this gives the impression that maintenance is not a limited word, and therefore it cannot be restricted to the few items. But such is not the case, and it would be wrong to hold that maintenance is limited in the nature and scope only to the three major items, that is food, lodging, etc. Therefore, Imam Abu Hanifa and Imam Malik have made the position clear when they state no amount of the maintenance has been fixed in the Quran or by the Sharia. Uh, it depends on the financial condition of the husband and wife and the country, and it changes under the different conditions, time, standard of the life in a particular country. Therefore, it may be concluded that maintenance within its ambit and scope would include all those material things which may be necessary and indispensable for the dignified survival of a human being in a given society, having regard to his or her social condition, status of the life in a given circumstance. And in this way, this expression maintenance may includes so many things. It would includes means of subsistence, supply of the necessities and conveniences, aid, support, assistance, the support which one person who is bound to extend gives to another for his or her living. So means anything which may be necessary or indispensable for leading a quality of the life in a given society, every such thing, every such item which may be necessary for a quality life in the given society may be included within the meaning of expression maintenance in context of the right of a wife arising out of the marriage contract. Therefore, none of the legal system or social or customary rules attempted to define the expression maintenance, maybe Muslim law or maybe the secular law. All the laws, they were well aware that uh, this is the human based, this maintenance basically is the human being this is the this maintenance basically is based on the human needs arising out of the society, because something may be necessary for the support of the life in a given society, but that may not be necessary for the support of the life in a different society. Uh, Similarly, therefore, now earlier, say for example, earlier education means the basic education, means simply the literacy of the person was considered as education. But now with the change of the time and circumstances, now higher education has become the integral part of the quality of the life almost in every society. Therefore, earlier education, the expenses for the education could not have been or should not have been included within the meaning of the term maintenance, because in primitive societies, education, the importance of the education could have been lesser. But now with the passage of the time, importance of the education has increased, and it has increased to the extent that now it has become the integral part of the fundamental right in the under the scheme of the Indian Constitution. And therefore, now the expenses for quality education may be the compulsory part of the maintenance. Similarly, right to health now is a fundamental right, and therefore now the expenses for health, medical expenses have become indispensable and should be included within the meaning. Now, food not only the food which is sufficient for the survival, because for survival food may be something, but now food here means food which is necessary to keep good health. Clothing not only means just apparel, means which are suitable in a given society, and therefore the expression maintenance has not been defined either by the Muslim law or by the, it has been left open-ended and will be decided on the basis of attending facts and circumstances in case to case. Ladies and gentlemen, since maintenance is one of the socially recognized and legally legal right, not only it is not only a customary right. Of course, this right was enunciated by the customary law when the legal system was not so advanced. But even under the customary laws, there was provision for providing the maintenance to his wife. What was the nature and scope, that is a different question. But even under the customary law, before the advent of the Islam also, there was a provision for the maintenance, and the husband was required to pay the maintenance or to maintain his wife. Now, after the advancement of the society, advancement in the legal system, now it has been recognized almost by all the legal system as statutory right of the wife. And therefore, a provision, a right which was having the root in the customary laws and is recognized as a statutory law in the modern advanced legal system, must have some definite object behind it or purpose behind it. So what was the purpose, or what is the purpose or objective of the object of the maintenance provision? Because every provision, every law has its own social and uh, legal object. So the object, the fundamental or basic object of the maintenance provisions in personal laws as well as under the uh, secular law, maybe code of criminal procedure or some other laws, is to prevent starvation, destitution, and vagrancy of the dependents. This is the core objective of the provision for maintenance of a wife. And not only this, in addition to this, by making the provision for maintenance, Muslim law itself wanted to secure economic independence of the wife from the day first in the matrimonial home. Therefore, the principal object of the maintenance is to secure the financial relief to the neglected and destitute wife, discarded and neglected children, and old age and helpless parents. The provision for the maintenance, therefore, is rooted in the concept of socio-economic justice, which of course is integral part of the all the modern legal documents which are necessary for the governance of a country like constitution in India.